Mr. Chairman, thank you, members of the committee. This is a bill that one of the members of the committee, Delegate Campbell, has agreed to co-patron, which I'm very grateful for your support, Delegate Campbell. This bill has to deal with the fact that courts, we're looking at the best interest of a child, look at a number of factors. And one of the factors they look at is whether someone has abused that child. But one of the factors the courts do not look at is whether they have abused another child. I have a witness here, actually, who knows Delegate Campbell, who drove all the way from Abingdon for 4 hours to tell the story and actually have her son tell the story of what happened to him. Basically, I'll give you the brief and then I'll let him speak. The father of this child has a long history of child abuse. He was investigated for cracking the skull of a 2-year-old. There's affidavits from another girlfriend who beat her and pulled her hair and beat her black and blue and tore away her phone. He has a long history of violence. When Tyler's mother, who's here as well, Mr. Russell, came and was fighting over custody for her son, the court said, we will not listen to anything having to do with his abuse of other children, because the code says that you only look at family abuse. So if he cracked the skull of any number of 2-year-olds, any number of other children, no matter how many women he abused, we will not allow that in. And furthermore, her attorneys were afraid because part of the statute is you can't have parental alienation. Now there's an exception in the statute, and this is again in paragraph 9 of the bill, that says that the court may disregard the factors in subdivision 6 if there's abuse. In other words, we want parents to work together to have children. But if a guy has a long history of abuse, then you don't have to give that man custody of the child. We don't care about parental alienation. Her lawyers told her, and she'll talk, was that if she were to mention his long history of child abuse, his long history of beating up women and girlfriends, that mentioning it would cause the woman, Misty, to be in trouble because she couldn't, they would then accuse her of alienating the son from this extremely abusive father. It is a factor, it's not the be-all and end-all, it's one thing for the court to consider, and by putting it on the list, we won't have things happen like what happened to Misty's son, Tyler. I also am considering a line amendment to limit it to cases specifically of child abuse and intimate partner abuse, so it won't be a bar fight, it'll be nothing like that. And I'd like you to hear from Tyler Strom. Sure. Come on up. Tyler's 14 years old, and they drove 4 hours from Abingdon here today. We're very glad that they came.
Thank you. Yeah, they didn't drive as fast as Kilgore drives.
Got as fast as I did.
Come on up, Tyler. Tyler, good to have you here. Thank you for being here.
I'm here today to talk about events in my life that no child or adult should have to go through. I experienced mental and physical abuse from my father for many years. Sometimes he'd slap me in the face, hit me in the side of the head, punch me in the stomach. He'd pull me by my hair, pinch me. He'd say things to make me feel worthless, that I was stupid, and other names that included cuss words. He said he was embarrassed that I was his son. He even locked me in a dark room for telling my mom the things he was doing to me. The worst times is when he would slap me in the face and push me to the ground, and I would be crying and telling him to stop, but he would just keep going. In those moments, it made me worry that he would be angry enough to not stop hitting me to hurt me really bad or even kill me. I did everything I could, trying not to mess up, to keep his secrets, and not to tell what he was doing to me. And everything he kept to keep him from getting angry and losing his temper. On a couple occasions, I tried getting help and telling people, but I still had to go with him. I did whatever he said to keep him from getting mad at me. I lied to people. I did not tell people what was going on because he'd always find out and I would end up getting hit or something worse. He made me feel like I deserved these things and couldn't do anything right. I felt like nobody would help me. It seemed like his anger was unpredictable. Each time of abuse, it seemed like it was worse every time. In 2011, my dad's girlfriend and his kids moved in. There were several times he beat her up and even abused her kids. He was taken away by police in 2012, but we couldn't use any of this for my case because his abuse wasn't on me. I had to go through years of counseling and years of court when all could have possibly been prevented if the history of his abuse on my stepmom's kids were considered.
I appreciate you being here and appreciate your both taking the time and your bravery to come. How old are you?
14.
Well, I think you got a big future ahead of you, man. Thanks for being here.
Mindy could just briefly talk
Yep.
about how the court excluded the other evidence, if you could. She has that prepared testimony, but that's the essence, obviously,
Sure.
excluding the
Is the issue in that case that because the girlfriend, the living girlfriend, wasn't an official family of any kind, that abuse wasn't admissible? Is that the issue?
I think it was a double issue because they wasn't married and then she would move out. They would give her protective orders, like for example in the skull fracture in 2011, before we knew the physical abuse was going on with Tyler. They gave her protective orders, her son's protective orders, but she went home to her parents and then he wasn't included in the protective order. So then when I tried to take a protective order and went to the court and actually had to try to have it extended, they told me I was piggybacking on the case. It was two separate cases. The judge actually told me this. And the general culture through all these years, since probably 2009, back and forth, there's been history and allegations of abuse to myself, to other women, to Tyler, and the lawyers and attorneys, when I spoke to them, even guardian ad litems would see it as they see it as a crazy ex who may just be making crazy accusations. He was never convicted of any of this stuff. And actually, from 2009, we've been in and out of court, and in 2014 is when Tyler fully came forward with the abuse. And up until 2016, actually, Jeff helped us do a final protective order. I think he finally gave up and moved away because I think we were going to get the 2-year permanent protective order. But I think that if there was some type of wording that showed or that would allow some type of past behavior or excessive patterns of abusive behavior to be included in that this could have prevented Tyler from being abused. But I think attorneys, because that wording is not in there, they fear they're going to take, when they're planning their case, I think they're going to take the easiest route of how they're going to win the case or settle the case, and the courts are so flooded, they're going to, as an attorney, I understand why, but I think they need, some type of wording needs to be in there to include other abuse or abusive patterns, something that allows that to be in there, to give them the comfort to go forward to even approach that. Or there's not going to be a retaliation, or it's not going to flip around on the parent who's saying the abuse is going on to say, oh, well, this is just parent alienation. Because if I violated the order, while we were going through this case, I probably had 40 show causes that he was taking against me while he was the abuser. So,
we oftentimes want to be really careful not to legislate to a particular anecdote, a particular set of facts, but they do help inform what we do from a policy standpoint. So,
and I'm not only here as, I'm sorry, as a mom too, but I'm an MSW social worker, and just common sense psychological behavior, past behavior is going to be indicative of future behavior. And so I think it would just, to not allow that or even consider, just to have any kind of outlet that you could possibly wording to make other kids not have to go through this.
In Tyler's situation and in his father's situation, there were some protective orders you mentioned to the girlfriend. What were there ever any, and you said there were no convictions, were there any charges as they relate to Tyler, or protective orders, or any kind of formal action or formal investigation that resulted in action?
Tyler?
Yes, ma'am.
With just the protective orders, and then that was dropped. They wouldn't continue with it based on the abuse, the skull fracture of the other child, or based on the abuse to the girlfriend.
Right.
So because they wasn't married, they wasn't considered family. So
I can't remember if you were here last year testifying this bill, because you look so familiar, so I thought maybe you had. As you know, last year the sense of this committee was wanting to try to find a way to protect these sort of the most vulnerable in these types of situations without creating sort of a bunch of other problems. And I think a lot of us were kind of hoping that we would have a different version of this bill, maybe that it tightened around some of the questions that have been asked. So that's, I think, still where we are, is trying to figure out the way to capture the situations where, because of a technical loophole, because it's not, quote, family abuse, somebody who has documented abuse that rises to the level of convictions or full adjudication
one of their objections that I was listening to was that you couldn't imagine that they did this. But since our case had so much notoriety in Southwest Virginia, I have so many people, because of what I've been through, that send people to me, or there is so much of this that is going on. Parents who the dad has raped a female and the daughter still had to go. Or like the Griffin case in Glade Springs, which I'm sure y'all are aware of, that the mom was afraid the abusive dad would get custody, and he ended up shooting and killing both of them. Because there is this fear that's instilled in parents that this is going to flip around and I'm going to lose my kids if I bring this forward. And then the victims of abuse are too scared to come forward because they're a victim of abuse, and they know if they're not walking the line and keeping quiet, then they're going to get beat. And so I just think if there's a common sense thing, if you know you can fix it with a couple of words and you can prevent child abuse, then I would hope that you would do something in that manner today.
Okay, Chairman Gilbert.
Yeah, I think that we want to help in some way. My only concern, we may be a little bit, other abuse may be a little bit broader when it says any act involving violence, because violence could mean, different things. I think where it ought to be, according, and I was talking to Delegate Lefwich here, we ought to have something in paragraph 9, in number 9, where it says any history of family abuse, etc., or sexual abuse, or other abuse, and then something there other than have a specific section down here, because you'd want it up there under the best interest of the child.
I mean, the concern people have is the same concern people had last year, is depending on sort of the way you were brought up and the way your home was, there are some traditional parenting techniques that may be wrapped into this language from a technical standpoint that wouldn't rise the level of conviction or abuse, wouldn't lead to protective order, but could technically be violations in this context and could be used against a parent, but we ran into a lot.
I believe I can address your concerns.
And then we had the bar fight question and those types of
Right, I believe I can address your concerns,
Right.
and I even have a line amendment that I'd like to introduce.
Okay. Article Porta, line amendment.
Thank you.
While we're looking at that, anybody else have any issues before we look at the line amendment?
Well, one thing about traditional parenting,
Come on, Sam.
Sir, I mean, as I was looking at the particular law, it looks like to me that subsection 10 covers this, because it's a catch-all. It says such other factors as the court deems necessary and proper to the determination. And so I would think that to the extent that, and I don't practice in this area, and Delegate Toscano does, and I see the family law practitioners on the front row nodding their head in agreement, but that seems to me to cover, it's subsection 10 where it says such other factors as the court deems necessary and proper to the determination. And so I just think it's covered. It's just, and someone said something earlier about, well, we've got judges and we need to let them have the discretion. I think Lefwich said this last months ago. And I'm not done. And so it seems to me that would cover it.
Mr. Chairman, may I respond?
Yeah, Delegate.
So, the courts look at each of these factors, and as you've heard from Ms. Russell's case, many courts don't go beyond these factors. It is entirely still within the discretion of the court, because the court looks at these factors. It says at the very beginning, the court shall consider. The court can consider and reject the factor. The court can say the skull fracture wasn't so bad, or that the woman he raped, it wasn't a real rape. The court can consider everything. Currently, the courts believe that they can't consider it, and they haven't used the catch-all phrase to consider it. And you've heard that from Ms. Russell. You've heard that from other cases. All we're telling the court is, please consider this. Please consider this as one of 10 factors. The other thing that gets rid of the bar fight argument is exactly my addition in the line amendment. This would only affect children and only affect intimate partners. In my view, if someone has a history of abusing children, they're not someone that should have children around them.
Is intimate partners defined?
I define it in the code. I say person with whom the person committing an act has had an intimate relationship. If you prefer the word sexual, I can use it. I was being a little euphemistic. But that's the idea is this isn't a bar fight. This is domestic violence.
Okay. Delegate Mitchell.
Mr. Chairman, as follow-up to Delegate Lupasi's question, and I don't practice in this area also, but looking at these 10 factors, it starts off with the court shall consider the following. Of course, shall means mandatory. Any factors the court deems, under subparagraph 10, any factors as the court deems necessary and proper. So the court must consider any factors that the court considers necessary and proper. So if you're a lawyer, you put on evidence of this kind of abuse, which clearly is probative, clearly relevant, and the judge says, I'm not going to hear that evidence. I mean, that's a judge problem. That's the kind of thing we want to hear in December when we interview incumbent judges.
If we put this in the code, the court didn't even allow it into evidence. It was not like the court heard testimony on it. The court excluded the evidence as irrelevant to the case. She said it was piggybacking, that Ms. Russell could not even mention what happened to the girlfriend, could not even mention the cracked skull. The judge wouldn't even hear the evidence because it was not listed as one of the 9 factors.
The problem, what you're not hearing from folks up here, which is the same thing you heard last year, was every year we have bad judge bills, and then some years we have bad policy bills. And what we always are trying to do is get the distinction between, do we just have a judge who we should throw off the bench, or do we have a code that's written in a way that is forcing the judge to come to bad conclusions? I think what you're hearing, several people believe that 10 is such a broad catch-all that unless you have a horrible, you get a chance, unless you have a horrible judge, you're going to hear the evidence. Now, the flip side statutory construction argument, which is the level we should be having this conversation at, is that because 9 is specific, it trumps 10 as it relates to abuse allegations. And again, this is the same conversation we had for an hour last year, and the issue is, do we need to tighten up? Do we need to make it clear what 10 means? Do we need to add a new factor? Do we need to fire a judge? Do we need to do nothing? There's a litany of ways to respond to this. There is no question that some judge that Chairman Kilgore probably put on the bench in Abingdon totally screwed up. Totally screwed up an individual case, and that doesn't mean it's not worth fixing, but we're trying to do something bigger than address that case. We know that judge totally screwed up. I think what you heard from this committee last year from both sides of the aisle was that we thought that 10 was big enough that it wasn't worth creating this risk of this new factor. But
Mr. Chairman, you could have the code and you could strike sections 1 through 9. And you could simply say, in turning what's in the best interest of the child, a court shall deem whatever the court considers necessary and proper determination. And you could say, if the court wants to talk about the age, they can, it's in 10. They want to talk about the needs, you can, it's in 10. The reason we lay out these specific factors, and the reason we have family abuse in 9, is because we want the court to consider when a parent has abused a child. We're asking the court to consider that fact. Otherwise, you need no particulars in this bill. The other thing is that family abuse, as defined in 9, is exactly the same language, word for word, as you'll find in the section below. I actually had it originally in 9. Legislative Services put it below. But the other thing that's really important about section 9, and that makes it distinct from all of 1 through 8, is that 9 is an exception to parental alienation. It specifically says in section 9, if the court finds such a history, the court may disregard the factors in subdivision 6. In other words, if dad is a serial abuser and molester, you don't have to put the kids with dad. Under the code as it's now written, it says if dad is a serial abuser or molester, you must put the kids with dad. You must give your daughter to a man who's committed rapes of children. You must give your son to someone who has a history of abusing children, because otherwise it's parental alienation. And as Ms. Russell testified, lawyers are afraid to even mention past abuse, because 6 says you can't take the kids away from someone unless they're a family abuser. So if you abuse your son, yes, you can take the son away from dad. But if you abuse 20 other kids, you must put your child with that abuser. That's what the code says now, and I think that's what the code needs changed.
all right, so now we have a practical problem, which is that this subcommittee doesn't rewrite people's bills at their request, because you saw the time and on the bandwidth, and we're down to 45 minutes left. Hear the rest of these bills. But this is obviously a very important bill with some folks who travel a long ways to see it all the way through. So you all, I think are about to get up and propose the bill, have y'all seen the proposed line amendments? Do you have a copy you can give to them? Because we haven't considered the line amendments yet, and so we're gonna need input on the line amendments.
I'd be more willing to put this off till Monday if they want to take a look at the line.
Yeah, the problem is, I don't want Tom to come all the way up.
No,
here.
neither do I. But having heard the testimony, we could put it off.
And I think from most of our standpoint up here is, I really don't want to add a new paragraph. I would rather take care of it if we're going to take care of it and change in paragraph 9.
I'm more than happy to do that. That's how I originally
where we don't, where we're not having a whole different section.
Fair enough. I'd be happy to come back and finish off.
Okay. All right. Is there anybody who wants to move these line amendments now while we're sitting here? Again, if we can't get it done, we can hear it another time. I just hate for folks who drive this far not to get to see it. We do have a bunch of other bills. Now, most of the other bills, I know Chairman Ingram's in here. A lot of the other bills are for members of this subcommittee, so it's not the end of the world if we run out of time.
Mr. Chairman.
Delegate Campbell.
I think the bill can be fixed. I honestly think that I have a different amendment in mind that I would like to propose, and I certainly appreciate the travel that the patrons of the bill had to make in this regard. But if we could put the bill off and allow me to work with Mr. Levine, maybe that would be appropriate.
Yeah. I'm looking past Mark now, I'm looking at you. Would it be a grave offense to you all if we were to take the bill by with the understanding that we are attempting to craft some more workable language, understanding that you wouldn't need to come back up here and go through this experience again, although you'd be more than welcome to? Are y'all okay with that? I'm looking at you now too, because you have as much to say this as anybody back there. You're a good man. What grade are you in? Junior, sophomore, freshman? Nice. You're a good looking kid too, man.
Basketball
What's
player.
that? Gracious. Okay.
We may need him on the house team at some point.
That's what I was thinking. Maybe we should reschedule this for next week when the House Senate basketball is playing. And we can bring him back up and sneak him in as a ringer. The Senate has NFL players as their ringers, so you got to bring your A game if you come in and play with us. Okay, anybody up here have a problem with taking it by? Y'all good? All right, so we did not do anything with the line amendments. The bill is before the committee is introduced. We're going to go ahead and take it by for the day at the request of patrons. We don't know when it'll be back up again. Our policy is to move bills to the back of the line, but we'll see if we get some work done on this. And if you all would like to be back up for the bill to be heard again, we're happy to try to coordinate that if we can. Thank you so much for coming up here, and I can't imagine what you've been through, and I can't imagine how hard it is to come before a group of old folks like us and tell us about it, but thank you for being willing to do that. Okay, we'll take that bill by.
Thank you, Mr. Chairman.